Start. Tell me, 3, 2, 1, start.
The broadcast is now starting. All attendees are in listen-only mode.
Hello and welcome everybody. It's delightful to have you on board. I apologize for the 2-minute delay. We have a wonderful lineup. This is your host, Bernard Wolfsdorf, immigration attorney, EB-5 attorney. We have our usual participants, Mr. Jor Law, our securities, corporate and securities law, lawyer. Thanks, Jor. Wonderful to have you on board. Mr. Kevin Wright, our business plan writer and economic analysis provider. Kevin Wright, the principal at Wright Johnson LLC, and none other than Michael Gibson, our due diligence expert, our registered financial analyst, the man who can tell you the good projects from the bad projects. And wonderful to have our usual panelists on board. And today we have our special guest, Mr. Ali Jahangiri. Thank you, Ali, for joining us. That is EB-5 Investors Magazine. Ali is the publisher of the relatively new EB-5 Investors Magazine, top-notch publication. I encourage all of you to log on and have a look. In fact, today we have both EB-5 Investors Magazine and Michael Gibson, EB-5 Info, which has been going for many, many years now. And has huge resources in terms of evaluating the EB-5 program for those of you who are new. Now I'm looking and I'm seeing we have both experienced and inexperienced practitioners today. By the way, this is the 4th in our series for this year. This is the last of our webinars this year. We will be setting up a new series for next year, so those of you who have participated, please watch the bulletin. We'll send out an email to give you the dates for 2014. We're going to have a variety of guest participants. So again, those of you who are new to the EB-5 program, we're going to cover a basic introduction. I will actually give you some information for the rookies. So those of you who are gurus and experts, I see we have people like Yong Noi, major players in the field online. So you know, this is going to be boring for you, the intro part, but then we're going to go into the weeds. And the format today is Bernie's going to kick off. And then we're going to have my good friend Michael Gibson give us an update on due diligence and analysis, which I think you're going to find very, very valuable. And then followed by him, we're going to have Jor Law, who is going to deal with EB-5 capital raises, SEC issues and marketing. And then we will have Mr. Kevin Wright, who will update us on EB-5 regional center developments, all the new and latest information in the EB-5 program. And then last but not least, EB5investors.com, EB-5 magazine publisher, Ali Jahangiri is going to update us and enlighten us on all the latest with regard to his publication. A real expert when it comes to online marketing and specializing. And for those of you who haven't been to the seminars that he's hosted, watch those dates. He runs an excellent seminar. I have had the privilege of speaking at both of them. So with no further ado, sorry, that's an English phrase with my what I call phony English accent. So let's fire away. And what is that? Oh my gosh, what a boring slide. That's all about Bernie Wolfsdorf and his law firm, 18 lawyers. Actually, I hope to have 2 more. The bar results come out this week, so we'll hopefully push it up to 20 lawyers, filing a bunch of EB-5s, and that's all boring stuff. So let's fly through the basics because we really want to focus on an advanced panel with all our wonderful speakers. All of you know the basic program, 10,000 visas a year. Now let me scratch my head a second. There's 6,500 stuck at the California Service Center, 2.5 average per case. That'd be, let's do my math. I've got to take off my shoes to go beyond 10. So that would be about 25,000 visas just based on the pipeline cases, with another 10,000, or so new applicants probably going to come up in the next 12 months. Oh my gosh, how do we divide 10,000 visas amongst 30,000 applicants? Let me tell you how we do it, folks. We do something called retrogression. Retrogression is not a psychological diagnosis, or it probably will be. You're going to have to take medicine when you get retrogression, because the backlog is going to run at 2 to 3 years, is my personal prediction. Now, don't quote me. This is not legal advice, folks. Charlie Oppenheim, who runs the show, says it's only going to backlog about 6 months. When is this going to happen? Probably in around May, June, second, third quarter of 2014. But hold it. Wait. No, that's not going to happen. We can rely on Congress. We have always relied on Congress to jump in the last minute. White knuckle experience. You're waiting, you've run out of visas. We're going to have a 3-year waiting line for Chinese visa applicants. Really? We are going to have a 3-year waiting line? No, we're going to have Congress jump in and fix the problem, like they fix all the other problems. Actually, I believe they're going to fix the problem, because comprehensive immigration reform is sadly dead for this year. Everybody said it was going to happen this year. CIR, comprehensive immigration reform, we've got about 7 days left in the congressional year. The D's and the R's are fighting like crazy again. Oh my gosh, I'm getting a headache. But the good news is that Congress will get its act together and will fix the EB-5 backlog problem. How do you know this, Mr. Bernie Wolfsdorf? Are you just making this stuff up again? No, no, no. When we got the extension last time, oh, and by the way, the program expires in September 2015. Look at that, due to sunset. Regional centers expire September 30th, 2015. Let me take off my shoes again. What is that? Less than 2 years? Oh my gosh, that is kind of scary. So why do you think Congress is going to fix this problem? Well, because, it's only been 23 years. Could you repeat that? 23 years since Congress bothered to fix the numbers. 2 ways they're going to do it. One is only counts principles, and the other is actually increase the numbers. Is that going to happen? Let me take out my crystal ball. I see into the future. It is definitely going to happen. I'm about 50 to 70 to 80% sure. Bernie, those are horrible statistics. Yeah, well, I just made them up. Okay, so let's move on to I-526 petitions. You do not have to laugh at my bad jokes. In fact, you would be smart not to laugh at my bad jokes, but you can laugh at me because I like to be a little bit silly. So, what is this thing? Okay, you're all veterans. It has to be a new commercial enterprise. So can't I just buy that hotel down the road? Not so easy, folks. New, preferably ground up. It didn't exist there before. Apparently, immigration has a different version of new from the rest of the world. Brand new. Not new and improved, but brand new and improved. Otherwise, not so easy to do it. 500 or 1 million from a lawful source. Nope, we don't want dope money. At risk. What does at risk mean? At risk means you got to lose your money. Does at risk mean you must lose your money? Seems like USCIS thinks that sometimes, but no, the law says it has to be at risk, and the investment will create at least 10 full-time jobs, and to some degree, the investor has to be engaged in the business. Okay, we can keep on going with all this wonderful stuff. Last seminar, those of you who did not participate, we had Mr. Weiner, Dr. Weiner. Oh my gosh, our webinars are recorded. You can go onto our website. We just put on a new little button which says recorded webinars. Go on there, click onto your topic. It doesn't matter what your topic is. It could be religious workers. It could be PERM. It could be H-1B. It could be advanced EB-5. Oh my gosh, there's everything up there. There's got to be about 35 webinars. The only irritating part is a lot of them have me on it. So, I don't know if we have a fast forward button. But targeted employment area, 20,000 or less outside metropolitan statistical area, MSA, or, most important, unemployment of 150% at the national average. We were hoping that unemployment would drop. It's not dropping as fast as it should. So we still have quite a few TEA, but that's an issue. Those of you who are new, if you haven't read Matter of Izumi, go read it now. Just Google the phrase, Matter of Izummi. It will tell you about all the disasters we went through in 1998. Oh my gosh, so many sleepless nights. But the bottom line is we kind of know where we're going. This is like, EB-5 is like driving with a road map. Is it like Google Maps? No, they fixed that one now. But this road map kind of works. EB-5 adjudications policy, May 30th. Google that one. EB-5 adjudications policy, May 30th. There's about 25 pages for you to read. If you haven't read it, don't touch EB-5. Repeat, if you haven't read these two decisions, do not touch EB-5. You won't understand it. I've been doing it 23 years. I've read the decisions, and do I understand it? I think so. It's just that they keep moving the goalpost around every 2 minutes. So every time I turn, the goalpost went somewhere else. So investment must be at risk. There you are, your 3 precedent cases. Must be an equity investment. Okay, well, loan secured by personal assets, maybe debt instrument prohibited, no guarantee. We're actually going to go into that a little bit more with some of our securities experts. So what is a regional center? Start off with a definition that says it's not merely a defined geographic area. What do you mean it's not a geographic defined area? Somebody just got a 4-state approval. Somebody got a 5-state approval. Are we going to get a 25-state approval? Are we going to get a 50-state approval? Who knows? But simple bottom line is it's a defined geographical area. May not be sole jurisdiction. You have multiple EB-5 regional centers in different places. The purpose, it's worth reading that. For those of you who haven't read this, read. Promotes economic growth through increased export sales? Well, that's narrow. Is it promote economic growth or promote economic growth through increased export? That's very narrow. Improve regional productivity. Woo, thank goodness. That is broad. Increase domestic capital investment. Ooh, groovy. I'm a 60s kid, guys. I'm old. Increase domestic capital investment. And last but not least, job creation. This is a job creation program. Please don't forget that. We want jobs, 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 jobs. I'm running for election. I need jobs. Okay, so, what's the story now? I used to say 90% regional center versus direct. I dropped that to 80%. Where did I get that statistic from? I totally made it up. I'm not sure what the current statistic of regional center versus direct. I just know that direct standalone is red hot right now because we're filing a lot of those cases. So what are the perceived benefits of a regional center? Why go regional center? I have to be direct. Wait, Bernie, you're confusing everybody. You have to be, I'm being direct, but the reality is almost all of my Chinese clients prefer regional centers. Why? They have other businesses to run. They send the wife and kids to the United States. I got a little one-liner. Once you have a green card, you can become a resident. You're a resident for tuition purposes. You got 2 kids. Chinese can now have 2 kids. Oh, well, that's going to be down the road. But they can have 2 kids. Once they have 2 kids, they're going to send 2 kids to college. How much is that if you're out-of-state tuition? It's about $200,000 each. So you got 2 kids, $200,000 each. They have green cards to the EB-5 program. So how much does it cost for a Chinese national who wants to send their kids to state school? 0. They get free, 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 free. You put your $500,000 in to a regional center, you get green cards for the family, the 2 kids, you come and live in the United States, and you get in-state tuition, and you just saved yourself $400,000 or $500,000. That math didn't quite work, but you know what? That statement is true. Okay, so regional center affiliated with project may count direct jobs or full-time W-2 as well as indirect jobs. That's the wonderful part of this. What is an indirect job? Job shows to be created collaterally as a result of economic stimulus, blah, blah, blah. Indirect job resulting from EB-5 capital investment. So you put in the money creates the job. You use your multiplier table, your feasibility studies, your market analyses, and other economically or statistically valid forecasting devices. Thank you. That'll be Kevin Wright. We'll talk about that later. Who creates a regional center relationship? Project developers may set up their own regional center, and of course you have what I'm going to call professional regional centers who do a good job, and they may work with the RENA center. The regional center and the investment project are separate entities. It's very important to note this. People ask me, which regional center should I invest in? What do you mean, which regional center? You don't invest in a regional center. You invest in a project within a regional center, and they may be affiliated. So the regional center has the oversight or compliance obligation. They have to file the 924A, which, by the way, it's time to file your 924A. So choosing a regional center, doing your due diligence, you know, this is really going into Michael Gibson's arena. What's the track record, amendments, loan or equity, TEA designation, refund policy, other successful capital raises, complied with 924. Those are some of your due diligence. Michael Gibson does a better job. Regional centered versus direct, I'll fill you in next time. That's too basic for today. Lawful source of money, again, we'll fill you in next time. That's too basic for today. These are the critical issues. In order to put a 526 together, there are two critical components, your source of funds report, and then, of course, the project documents. You add A plus B, and what do you get? You get an RFE. A plus B equals RFE, request for evidence. Yep, that's the name of the game in immigration. So these are some of the issues on source of funds. We'll go into them some more depth. You've got to trace the money, EB-5 investor into the bank, from the bank into the project. Oh, look at that lovely new building. We've got some new graphics in there. So enough of Mr. Bernie Wolfsdorf. Bernie, you're giving me a headache. I'm giving myself a headache. How does that happen? Okay, folks, let's go on to somebody relatively calm, relaxed, none other than Mr. Michael Gibson. Those of you who want to get due diligence done, that's a good one, due diligence done. That's 3 Ds, good alliteration. If you want to do due diligence and get your due diligence done and do due diligence on your due diligence people, oh, that was good. Do due diligence on your due diligence people. You have to hire somebody that's got a CRD number 157403. None other than the Mr. Michael Gibson. Michael, tell us, what's the story with risk and EB-5 and doing due diligence on your due diligence people? That means I've got to hire somebody to do due diligence on you, but I don't think so. I think you know how to do it. Michael, take it away. What's the story with due diligence?
Fine. Hey, thanks very much, Bernie. And by the way, record time on the intro. I'm impressed. The first time we did this, I think it went on for about 45 minutes.
Oh, God.
You did
Do
really
I talk
well.
too much? I talk too much. That is a problem that I have. But, you know, we have a jam-packed panel, and I really want to get to the back of this because all the good stuff is going to be in the last minute. By the way, those of you who can't make it, remember, these webinars are recording, and they are live on YouTube. So you don't want to go off there because one of the things you're going to be able to do is you're going to be able to ask questions. You can press your chat function and ask questions, and we're not going to leave until we've answered all of your questions, or at least I'm not going to leave. So, Michael, tell us about due diligence.
Sure, and I appreciate that. So I'm going to go through my slides fairly quickly. I only have 10, and most of them we've already seen from the previous sessions. The actual slide on due diligence we'll cover in about 2 or 3 slides, but let me just begin with the premise. Why is everybody tuned in today? Why are we interested in these subjects? And you brought up a lot of the points of why people should be interested in, because what we see is with USCIS, a very difficult landscape in trying to determine what projects are going to get approved and under what conditions. And I will leave all of that immigration-related issues to the immigration attorneys and to the economists to explain what counts as sufficient for USCIS. But our concern, and really when I say us, the clients that we represent, who are the investors and the attorneys who recommend their investor clients to us, what we're concerned about are two essential components, and they all have the same question. They all want to know, if they invest in this project, Project A, will the conditions be removed at I-829? And secondly, will the principal be returned or not? And what are the probabilities related? Because as we know, and as we've seen just in the past 6 months, a number of projects have gone bankrupt or been the subject of certain investigations. And in those cases, all of the investors are facing either potentially some immigration issues, could be removal or re-adjudication of their petitions, as well as a loss of principal. So,
Michael, just to be rude and interrupt, as I often do, what are the names of these projects? Have 3, 4, 5 projects have collapsed in the last year or so, and some people are not sleeping that well recently? Who are these? And I know we can all go to eb5info.com, eb5info.com, or usadvisors.org and find all this information. Your website is full of all these amazing reports on regional centers. But give us the Cliff Notes or Coles Notes version. Who are the 5 or 6 biggies that went down in the last few months or years?
Right. Well, actually, and thanks for that, Bernie. I would refer everybody to our news site, eb5news.com. We kind of keep more of the resources on info and the news on the news. But the big one, of course, which occurred in February, was Chicago, the Chicago Convention Center. And I think anybody who's been to China, I know you go quite often, anybody who's been to China since Chicago, they are all extremely concerned about the representations that are now being made to them by the issuers. So if you have people on the call who are planning to go to China and pitch your projects, you would find the atmosphere completely different from before Chicago, whereas before Chicago, people really did not ask any questions. They would look at your team, and if your team was composed of people that they recognize, that would be sufficient for them to say, yes, we will now go and present your projects in front of the investors. After Chicago, I found quite a bit different atmosphere, whereas they like to see who your team members are, but more importantly, they want to see the fundamentals behind the deal. So since Chicago, we've had a huge number of other issues, and what I would say to you, Bernie, is not only are there 5 or 6 that we know about publicly, but I will have to tell you that we've been told of at least half a dozen other projects which are in stages where they are now, it looks like what we call lights out, where they have run out of capital to develop the project, and they are in a state where unless they're able to raise more investment, these projects will also fail. So what I would do is, rather than pointing out just 1 or 2, which are either under investigation or litigation, or as in the case of South Dakota, which had the northern beef packing plant, which went bankrupt, and I think actually the sale is next month, the sale of the assets. Instead of pointing out 1 or 2, what I'd like to do is focus on what are the issues that all investors, their attorneys, and the agents who represent them should look at before deciding to invest in a project, and then after the investment, what activity they should do to ensure that their client's investment is protected and there's sufficient audit and due diligence going forward.
Michael, I totally agree with you, and I think it's really important, we can learn lessons from those that are out there, and there's sort of a standing joke, every regional center and every project has a 100% approval rate, except the statistics don't bear that out. So we know that's not accurate, and one has to do our due diligence. But I just want to take a slightly contrarian position. I was in China when the Chicago thing blew up, and it was a nightmare. It was scary. The press were going crazy. It was a feeding frenzy. I actually think we're in the post-Chicago era. And in the post-Chicago era, what we have now is a much more sophisticated, educated a market in China. The agents are smart. The regional centers have learned to be smarter. People are kicking the tires. The bottom line is the consumer has become so much more sophisticated, and they are looking carefully at these critical issues. And remember, Chicago has a moderately happy ending. Everybody got their money back, and most of those people, we put refiled several cases into new projects, which we are expecting will go smoothly. The only problem that we're having, and I'm fighting 2 of these cases, is the age-out headache. Because the minute, if you had an age-out lock-in, if you have to refile, you lose that. Michael, I'm rudely interrupting, so please help us here. How do we evaluate, regardless of which regional center or which project, what should we be looking at?
Right, and Bernie, I agree 100% with you. The market has changed, that's my point, but I agree 100% that everybody in the industry has become more educated, and I would say, again, for the people who are listening in on the call who are planning to go offshore and present projects, and that includes the attorneys who represent the developers, is that the audience for these projects has awakened, if you will, and they are asking for much more documentation and verification. So it has caused a substantial change in the market, and for the issuers and the attorneys, they should be prepared when they go over there to be ready to answer all of the questions, but not just in kind of a trust me, these are what we're saying, you should accept it, but bringing in third-party feasibility studies and others, which would then help them verify that what they're telling the agents who are hopefully going to represent their projects, that what they're saying is true. Okay, so on this one, just again, we went over this slide in one of the earlier reasons why projects fail. These are the most common, systemic and non-systemic risk. We'll talk about that in a little bit. You can advance here. I think we're done with this slide. Due diligence. So you asked before, what is due diligence? Due diligence actually came out of when the SEC was formed, 1933. They came up with these standards which apply to the broker-dealers when they're representing projects to investors. And these are the most basic definitions, but what we want for the entire industry to realize is that unless a third party is involved to try to determine, or in the case of the immigration attorneys who are filing the petitions, unless some sort of reasonable analysis is done of the investment, then what we would consider there would not be due care for the investor. At least that's my perception, is that if there is failure, there may be questions as to what was done to help the investor make the most appropriate decision, the investment decision for them. And in many cases, as I say, before Chicago, probably 95% of the investments were done without any due diligence, and we see that changing.
So, Michael, am I supposed to go out? I'm filing a 526 this afternoon. Am I supposed to go out and see if the permits actually got pulled on the construction site? Is that part of my job as an immigration lawyer?
I think the courts are going to decide that. Right now, my sense is that, and we'll talk about the rates of failure here in a minute, but a lot of these projects are going to fail. I mean, just statistically speaking. In fact, I would argue that more than half of these projects are going to fail to either achieve the immigration conditions or the investment, and there's going to be litigation. There's no question about that. In fact, my guess is that when you start running the series for 2014 and possibly 2015, you're going to include a litigator on here because there's going to be so much litigation in the industry, simply because once investors lose money or lose their petition for residency, and you have to imagine a family from Iran who is here and they have their 829 denied and they're possibly have lost all their money. They're very smart people. These people have tremendous amount of wealth and resources. They're immediately going to hire a lawyer and they're going to start suing everybody. Now,
well, thank you, Michael. What do I need now? Is it Paxil? Is it Valium? What are the current things about? I'm not going to be able to sleep at night after Michael, but has given me the fast forward analysis here, but it's kind of true. I think we do need to be very careful. I'm a little bit more optimistic, but you know, the simple reality is that one cannot overemphasize. So sorry for that rude interruption.
No, and you know, it's the people you went to law school with, Bernie. Some of you became immigration attorneys, others became litigators, and the problem is they're in business too, and what they're going to see possibly is that there may have been some fraud, maybe some misrepresentation, maybe the investors were not told the whole truth. Now, whether that is the fault of the developer, the regional center, or in what I'm thinking is the immigration attorney, they may be put into a very difficult position by saying, let's say you are, you know, facing some sort of action, and the litigator may ask you, well, Bernie, why didn't you, you know, at least find out if the permits had been issued on this project? And I think that's a question that immigration attorneys are going to be asked in the future. I don't know what the defense is, but my sense is that the more you do to determine the viability of the project, the better and safer harbor you would be in.
Well, you know, it's kind of really interesting. Just so you know, I was doing a site inspection on a regional center yesterday, and they were telling me how the Chinese consumer wants to see the photos. They want to see that camera running on the project. And the regional center, well, you know, at this point it's just dirt. So I have a camera running on a pile of dirt, but they want to see that thing building. They don't want to get taken. So the market has become sophisticated, and whether that building is really going up or not is no longer going to be a hypothetical thing, because cameras are going to be the norm right now. If you say you're going to start construction in June and breaking ground, the customers want to see those bulldozers working. That's how sophisticated the market's got. So should I be fast forwarding here, Michael?
Yeah, yes, you can, absolutely. I want to get to the statistical probabilities, but basically this is for the immigration, just back just briefly on this. So when immigration attorneys call us and say, what can I tell, as you've just done, what can I tell my client, what should I not? We basically separated between information and advice, and I think the one concern that I see a lot of immigration attorneys doing is that they are actively promoting projects. They may not consider it to be promoting, but they're going and speaking in front of audiences. Not only here in the United States at conferences, but then offshore on behalf of their sponsor. And to many people, it may look as though they are giving investment advice as to which projects to select. And I think that gets them into a bit of a more problematic area. The rule of thumb that we use is information is general, non-specific, how many 526s have been issued, things of that nature, versus advice. When you give somebody information which then leads to an investment decision, that's advice, and whether you consider yourself to be an investment advisor or not, somebody else outside may consider you to be if you are giving your clients investment advice.
And by the way, we'll get to Jor's slide, and I will leave it where Jor has a wonderful disclaimer. Let me please make it clear that disclaimer applies to this entire webinar about how we are not providing professional advice and that you need to consult with a professional. This is a chat format. We have some fun. We provide some information, but nothing that you're going to hear here is professional advice today. You do have to do that little follow-up thing if you want professional advice. Sorry, I'm going to put, after listening to you, Michael, I usually have 2 or 3 sleepless nights, but I'm going to take Jor's disclaimer, put it on every second page of this, and make sure every client gets a copy of it. So do I fast forward here to positive deal aspects?
Right. Yeah, and these are some of the things. So when we're dealing with clients, we're often asked, what are the positive deal aspects? And a lot of these things to us, they're common sense. But what the problem is with EB-5, EB-5 came from, it's an immigration-related program housed under USCIS. So a lot of the promotion into these projects has been about whether or not they have this 526 and 829 approvals, which, to be honest with you, we really don't factor in. We like to see that they have one 526 approval, meaning that USCIS has approved the methodology for the project. But whether they have any 829 approvals or not is I'm not going to say it's immaterial, but it's very small in our overall consideration of what projects we feel will succeed. And I say that because the projects that they have 829s approved for occurred long time ago in different economic conditions, and they could be significantly structurally different from the ones that they're offering right now. So these are the things, these are the tangible items that we look for when trying to determine which projects we feel have a good chance of success.
Michael, just, let's take number one, capital stack. We keep hearing it. Those of us who went to law school unfortunately didn't study enough finance. Tell me about capital stack. I mean, where's the EB-5 capital in the stack? How does it work? What are the ratios we should be looking at? What are some of the criteria, just going into the weeds on that point?
Yeah, that's a great question. So what we're looking for here is, are other people investing in this project? Or is this just a pipe dream from the developers, meaning that the developer recognizes they cannot get any source of U.S. funding, either traditional, non-traditional equity debt, and they really have hit the end of the road. And this is where we start to get significant concern when we see a project that comes to us and it has no other external source of funding other than EB-5. There's a number of red flags that are raised. The definition of the capital stack is all of the capital that's required to develop the asset. And one thing is true, with unlimited sources of capital, you can develop anything. Any bad idea can be developed. But unfortunately, the reality is that all capital is finite and it all comes at a cost. And so when we're looking at a deal, we want to see, and it's not just to see that they have enough money to complete the development and start funding operations. And most startups, they're negative cash flow the first 3 to 5 years anyway. So you don't need just enough money to develop the project, but you need to account for the negative cash flow once operation begins. So we want to see a bank involved, because the bank is not only offering their money or their shareholders' money, but they're also doing audit and oversight, which is tremendous for the EB-5 investor.
So, I have a project, and I'll just give a unabashed plug to my client Continental, and we're filing an assisted living project right now where the developers got 50% of their own money in the project, meaning skin in the game. Now that is an extremely high percentage, it's a good percentage, and yet the market doesn't seem to fully understand how valuable that is when you've got an experienced developer who's put 50%. Is that a good ratio, Michael, or a bad ratio?
Oh, it's unbelievable. It's outstanding is what it is. And again, it also depends on where they put the limited partners, the EB-5. If they put them in a priority position, let's assume that both investments are equity, or one is debt and one is equity. But the point is that if the developer puts in 50% and pledges all of the collateral first position, then to the EB-5 investors, to me, unless there is a catastrophic failure before operation commences, to me it doesn't seem like there is a negative to this, because assuming that they can build sufficient value such that the remainder of the 50%, which would be pledged as collateral, could be collected. Let's say they, worst case scenario, worst case is they take the 50% and then they run to Mexico. But let's assume that they build the asset and they ran out of $2 million and they couldn't open the doors. So it goes to auction, they sell it. If the collateral, what has been built to date, has sufficient value to repay the investors, and that's almost a no-lose situation, except for in the case, like you say, where you have immigration jobs that are dependent on that and you have some age outs. And that case, that could be problematic, but 50% developer equity is a dream.
Great. So, the fact that I had a project 15 years ago that had 100% approval, is kind of irrelevant. The question is, where are we in regard to EB-5 capital in this particular stack vis-a-vis the future? Let's keep going. So what are the negatives?
So there's quite a few. I think from my standpoint as an investment advisor or analyst, the worst thing that we have in EB-5 is a lack of transparency, and it's not just from the developers or from the regional centers, but it's also from USCIS, and I've complained about this publicly. But I feel if USCIS was more forthcoming about all of the information that they're going to collect in these I-924As, that we would be in a better position to determine which centers are out there raising funds, which projects are being financed. But even from the regional center standpoint, we don't know who the members of the team are, what other sources of capital is involved in the stack sometimes, and who's loaning that, what the conditions are tied to that. And I understand there's some competitive advantages, but for the investor to make an investment decision that could potentially affect their life and the life of their family, we want to know as much as we can, and the more transparent and open the centers and the developers are, the better everybody in the process is. So that's our number one issue. We want to get as much documentation as possible. Some of these other things we've discussed. The biggest, sorry, go ahead, Bernie.
No. I'm just going to remind the audience that we will both post the PowerPoint and the recording on YouTube, and all of you can access it afterwards if you want to really study this, because the truth is this is really great stuff. Sorry, Michael.
Right. The last thing I was going to say about this, the biggest problem that I see from the real-world development finance, when, for instance, the deals we would see when I was at Citibank versus the deals I see in EB-5, is the high percentage of soft costs. And the reason, I think, is that a lot of the developers want to make their money up front. So we are seeing projects come to us with over 50% soft costs. When you think about it, what they're saying is for every dollar invested, 50% is going into, I mean, you can't believe the line items in the uses of funds. A lot of marketing, a lot of, I don't know, it's completely ridiculous. And it's not going to actually building or furnitures, fixtures, any of that. So one thing I would just say is that when you are evaluating the offerings is to make sure you look at the sources and uses of funds and how much of this is hard versus soft, because if you see a lot of front, I saw in many of these where they bought the land, let's say for $1 million, and then they sold it to the limited partnership for $5 million. I mean, I've seen this dozens of times, and it's in the space of a period of a month or two, and so that to me, and that's where the immigration attorney really needs to be careful, because if the project fails, a litigator is going to say, couldn't you see that this was fraudulent activity? And I think that's where the attorneys really need to be on the ball when they're looking at the uses of funds.
Yeah, Michael, I found that to be a very important one as well, which is, the land was purchased for, $1 million, and suddenly it's on the books valued at $10 million. How did it go up that much in 3 months? So, what are the probable outcomes if you don't do your due diligence correctly? Are these current statistics, Michael? Have you updated them? Yellow one. Did we go lose somebody? Michael, are you there?
No, sorry, I'm here. No, I'm
sorry.
Here. So, yeah, can you hear me?
Yes, sir.
Can you hear me, Bernie?
I can hear you now.
Okay, sorry. The left-hand side is immigration, USCIS dependent. So we know right now that 4 out of 5 people are going to get both the 526 approved and then the 829. So the overall immigration, I think it's 68% of the people who applied will eventually get their 829. That's not really a high bar to set. It's not 100%, as many people in the industry would like to promote, but let's say it's close to 70%. And for those who missed the 526, they may reapply, so that number could be higher. So we know, let's assume 4 out of 5 get their 829 removed. That's not a problem. That's pretty good. The question is, what about the people who make the investment? Will they get their money back? And so we ran through all of the slides before, but this is the summation. Essentially, for the 4 possible outcomes, these are the probabilities. The right-hand side, we get this information from the Bureau of Labor Statistics, which has been compiling this data since, I believe, the 50s. And this has to do with project failure, how many businesses start versus how many are around after year 4, 5, 6, and 7. And these numbers don't lie. As the guy in the commercial says, if you argue with math, you're not gonna win. And So what I want to point out to the people is that when you combine the possibility that your clients will not get their 829 conditions removed, about 20%, with the possible failures in the industry, in all industry, all asset classes, that these are the numbers we're looking at. And if you want to go to the next slide, this shows the pie chart of the different probabilities, and then just go one slide further. This shows the outcomes. So what we're saying using these statistics is that we're assuming that 2/3 of the projects will fail to either deliver the 829 conditions removed or full return on principal. Again, the numbers are from USCIS and the BLS, and I think this is what immigration attorneys are facing. They're looking down the road, like for your clients right now, you're filing the 526 for. You're looking at a point in time where maybe 2/3 of them are not going to be happy, and how does that affect your business? And I guess that's a question. That's really the question that I want to leave with the audience: is what could happen in the event that your clients don't receive the 829 or get their money back?
Where do I get a Paxil prescription? Is it Paxil? Is that the new one that's in? So what are the 5 stages of project involvement for both developers and investors, Michael?
Sure. Now, we've been developing, I mentioned this the last couple of times, we've been developing a due diligence package for the issuers and for the agents and the investors. What our concept is that due diligence, many people assume that's what you do at the beginning and then you forget about it, but as you've rightly pointed out, that now the investors are saying once the 526 goes in, they want to know. So what we've done is we've talked to a number of service providers in the industry, and this list is not exclusive. There's other people coming on, but the goal is for the issuers to engage with these third-party service providers to do not only due diligence at inception, that is before the clients release their capital or sign the subscription documents, but then beyond that. So once the developers have released the capital, you have people doing site visits. So having the camera on the site maybe is not bad, but how do you know that they didn't take that camera and put it across the street to film the Holiday Inn? I mean, your clients who are in maybe Beijing or maybe they're in the United States now, maybe they're not on the site, and maybe the developer, if he has bad intentions, why doesn't he just take the project and move the camera? So
Michael, my question is, based on that point, is are you at the $1 million frequent flyer level yet? Do you get like free everything? Because of this, you're in like a different city every day. I'm off to Miami for the conference down there. Yesterday I was in Phoenix, but I'm nothing like you. You're in a new city every time I talk to you. And I assume that's what you're doing. You're out there checking out, doing a due diligence on-site, in-person evaluation, correct?
Well, we've almost stopped doing the site visits simply because there's too much detail to know. We're not professionals, construction developer site auditors. So we've really outsourced this to other companies. Most of our time now is actually spent meeting with immigration attorneys to try to explain to them the risks involved for them and for their clients. And a lot of the actual ongoing site inspections and the auditing of the financials is really best left done to experts who know this. For instance, QPM, who we list here, they work for Starbucks, for Federal Express, for Wells Fargo, for Home Depot. They do all of their site inspections. So there's no point in me going, there's 500 regional centers now. Well, there's no way we could do that. But we can outsource this job to third-party service providers, and they actually do it better, more efficiently, for far less money. And the result is that the immigration attorney is informed, the agents in China are informed, the investors are informed, and so that way if there is a failure, let's say if there is a bankruptcy, the immigration attorney or the agents can say, hey, we gave you all the reports, we gave you all of this information. Things will fail beyond for reasons that have nothing to do with the lack of capital or the market, they will simply fail. But if the attorneys and the others who are involved in the promotion of this are upfront and honest with their investors, we don't think that there's going to be a lot of damage.
Well, Michael, you know, it's been a while since you came to visit me in lovely, sunny Santa Monica. It's November. Actually, it's third week in November, almost Thanksgiving, and it's like 75 degrees outside. So, Michael, time to come and visit me again. Here we've got EB-5 info. Michael, the new website, you need to update this, EB-5 News, but I assume we can find it through the other websites. What was that website again, which you called EB-5 News, where you're reporting?
Yeah, that's it, eb5news.com.
EB5news.com. Michael needs to update his template here. You know, wonderful. There it is, right up top, EB5. The graphic is so cool that I didn't even see it. I was reading the websites below, EB5news.com. Wonderful source of information. Michael, the guru on due diligence, he almost invented this concept in the except you know, it did exist before him, and now if we're not sufficiently paranoid and nervous, and I think paranoia is an appropriate emotion, because you really need to be afraid, do your work carefully, and you're going to end up with a winner. We have nothing other than and thank you, Michael. We're moving on to Mr. Jor Law, Homeyer and Law. This is the go-to firm that we work with. Two experts in the arena going to deal with EB-5 capital raises, SEC issues, and marketing. There's the disclaimer. That disclaimer, folks, applies to everything I have ever said publicly or otherwise, other than in a legal consultation. Maybe it applies in a legal consultation as well, but that's what it's asking you to do. This disclaimer applies to everything. We're going to paste it everywhere. So, Jor, thank you for joining us today. Securities in a nutshell. What's the purpose of these laws? Why do we have them? Fill us in. Are you going to make me more nervous than Michael Gibson just did, or are you going to help us solve the problems? Actually, what Michael told us was invaluable, and it should not make us nervous. We should be nervous if we don't know or listen to what Michael said, and we should be nervous if we don't listen to Mr. Jor Law. Jor, take it away.
Yeah, I'll make this reasonably quick since this is, you know, number 4 or however many of these webinars.
People are not getting bored, Michael, Jor. They are just getting into it. But we want to know the latest, because even though you spoke about this last time, there's been changes. There are constant changes, and I want to know where the goalpost is so I can take a kick and get that ball in the goal.
Got it. Well, let's start off in securities. You know, for the purposes of, you know, the call, you should just assume that most EB-5 capital raises involve securities. You know, generally, if an investor is investing into a company and they're not actively involved in the management of that company, and not actively involved in USCIS's determination, but actively involved in kind of a general layperson's determination, and they're passive investors, you know, as with most EB-5 offerings, then generally they would be investing in securities. So what are the goals of securities laws? They're essentially to protect the investor, and they protect the investor by having companies that are raising the money provide adequate disclosure, in other words, tell the truth, and prevent fraud by not lying. And the way that the federal laws and state laws and the regulators enforce this is essentially they require that anyone that's raising capital gives full disclosure of material facts. Now, there is a concept whereby if you're raising capital, you would generally have to register your securities, and then there's a bunch of exemptions for why maybe the government feels that in this case, because you're dealing with a limited number of people, because you haven't publicly advertised, because everyone that you're dealing with is smart and sophisticated and super rich, that maybe there are exemptions that are available. But despite all the exemptions that exist from actually having to register your securities, you always have to provide all material facts just as a matter of principle. You know, they call that anti-fraud liability, and the idea there is... Go ahead.
Sorry, that was rude again, rudely interrupting, but fill us in a little bit more. Rule 506, that's a big one. Let's go into the weeds a little bit on Rule 506 and on the Jobs Act, which will update us. What's new in the zoo? What do we have to learn? What do we have to be aware of? Because some people are saying, well, you know, with all the new changes with the Jobs Act, it's a whole lot better. Other people are saying it's a whole lot worse. Demystify this for us, Jor.
Sure. First off, Rule 506 and Reg D touches on an exemption to registration requirements. There is no exemption at all to the fact that you just have to be, you know, careful in providing all material information. Otherwise, you'd be committing fraud. But Rule 506 is a rule within Reg D that says if you do it this way, this way, this way, and this way, then we will consider you to have done a private offering, which you do not have to register with the Securities and Exchange Commission. You still have to file a notice with the Securities Exchange Commission. You still have to file a notice with the states, but other than that, no registration. So that's what 506 is. And on the slide, you'll see a few of the line items. Now, traditionally, and this is the hot topic these days, is traditionally Rule 506 was a safe harbor for what was called 4.2, which in the slide you see as transactions by an issuer not involving any public offering. And of course, if it didn't involve a public offering, you know, it makes common sense that you couldn't generally solicit and advertise. And if you did, you would violate 506 and no longer fall under the safe harbor. But this has changed. The Jobs Act passed, and the Jobs Act enabled.
Thank you, Jor.
The Jobs Act passed, and it got signed into law on April 5th last year, and that enabled folks to do a general solicitation and general advertising in offerings made under Rule 506. That's huge. Two kind of conditions on it. One is there can't be bad actors at the company level, and there's a detailed definition for what a bad actor is, but, you know, someone that, you know, you think is a bad person that's committed, you know, securities and other crimes in the past, bad actor. Just remember that. You know, more importantly, the thing that most of you are really focusing on is what does this mean that I can generally solicit now, but all the purchasers of the securities have to be accredited investors. And not only do they have to be accredited investors, but you have to take reasonable steps to verify that they are accredited.
So, thank you, Jor. That's very, very helpful. So this Jobs Act was passed in April of 2012, but, you know, help me here. We're in November 2013. What's the story with adoption? Why has it taken so long, and what does it mean?
Well, unfortunately, you know, as with much of EB-5, the delays, you know, the government. The final rules were not adopted, you know, implementing the law. Although the law passed, they weren't effective until rules were adopted by the SEC. So the SEC released final rules on July 10th only, and those rules were effective only on September 23rd. So you're looking at, you know, maybe about 2 months, coming up to about 2 months since the law has been active, and people are definitely very interested in this and starting to take advantage of it, and it's starting to trickle throughout the EB-5 space as well. The key thing to know, of course, is that a lot of people were struggling over what constitutes reasonable steps, and there was no infrastructure around for what constitutes reasonable steps. The SEC didn't define exactly what reasonable steps were. They kind of said that, well, we're not going to tell you exactly what reasonable steps are because we don't want to tell you have to do it this way and then everyone does it this way, and then and that precludes every other possibility. However, right after they said that, they did provide you know, 3 or 4 methods which they thought that if you did it this way, we would think that you took reasonable steps. And then they provided a methodology to verify someone's income. They provided a methodology to verify someone's net worth. They provided a methodology for an existing deal that already said that they were a accredited investor for them to just tell you, hey, I'm still a accredited investor.
So, Jor,
the key thing,
sorry, butting in again very rudely. Don't have a red light here which I can press, but so those are some of the non-exhaustive. And in the old days, we used to clients had to fill out a questionnaire and disclose all their assets, and then they'd call me 100 times and ask me, what does question 3 mean? What does question 4 mean? And drive me crazy all day answering these questions on this questionnaire. But some super smart guy, I'm not really sure who he is, some Columbia law graduate, this really smart securities lawyer, came up with an idea. And excuse me, guys, for those of you on the audience, this is a direct and heavy plug for Jor. He doesn't give me a commission. He should, but he doesn't. But Jor just came up with this really cool idea, that there's now a service where you can actually log on, and it's brand new. And I'm plugging Jor right now. I do not get any commissions from this, although I certainly deserve them. So, Jor, what is this verifyinvestor.com thing? I underlined it and I put it in bold. I know you want it to be modest, but modesty doesn't fit into the spelling of my name. So tell me, what does this thing do, this verifyinvestor.com? And if it gets it wrong, can we sue you just like Michael Gibson said everybody's going to get sued?
Yeah, no one can sue me. It's against the law to sue me. So
okay,
think about it.
Got it. Whoa.
But no, seriously though, let me try to keep this educational and not self-serving. Third-party verification, which is verification by a licensed attorney, CPA, investment advisor, or broker-dealer, is probably going to end up being the gold standard. Because that's the one where it's easy to get a letter from an attorney that says, hey, I've looked at this guy, and this guy is an accredited investor. And that's one of the reasonable steps that the SEC laid out. The problem, of course, is that, God darn it, those lawyers, they cost an arm and a leg. They're horrible. And, I'm one of them, so I know that. And I realize that it's not cost effective to have a traditional law firm or traditional CPA provide this sort of service. So that's why I created verifyinvestor.com, which is essentially a service that's provided as software as a service, and it drops the verification cost down to
okay, enough plugging. I plugged, you plugged, but we actually had Michael Gibson have a look at this, and trust me, Michael Gibson is independent, doesn't plug anything. Michael, what were your observations about this thing? Does it actually work?
Yeah, I have to say, I was so impressed. This is the single best thing that's happened to our industry in a long time. And the problem that Jor, and I know he won't say it, but the problem that Jor has solved with this website is it's just so substantial that it's hard to describe, because all of the we deal with a lot of regional centers, and we have seen everybody's accreditation process, and it's all a mess. None of it is standardized. It takes all of our clients, they're incredibly frustrated with this. If every regional center operator who's listening into this call does not adopt this as their de facto standard, they are crazy, because he has solved probably one of the biggest problems in our industry, and he's done it very economically, very elegantly. I can't say enough good things about it.
Wow.
I love this service.
I'm like, whoa, I'm shaking. Michael, never heard you talk like that in your life. Are you sure? I'm just going to make a bad joke. But, that is truly amazing. Bravo to you, Jor. The truth is, this has just been launched. I haven't had a chance to go on it, but with Michael Gibson giving you a green light, looks like you've done something useful that will make the Jobs Act positive, and accreditors can go on board here. Hey, make sure my clients get a discount for this thing. Proposed amendments. So talk to us a little bit about the proposed amendments, Jor, and then we'll move on to none other than the incredible Mr. Kevin Wright.
Yeah. So The Jobs Act, of course, the key thing you have to do is you have to verify accredited investors. And everyone thought that was a pain and very cumbersome to do, except for now there are options like verifyinvestor.com make it a little bit easier. However, it's not, happy in Disneyland. There are proposed amendments along the way. And one of the things is that, they're going to increase the kind of Form D requirements, or they're proposing that they should increase the Form D requirements. And Form D is a short notice that you file with the SEC, kind of telling them a little bit of information about your raise. And typically you would do it 15 days after your first sale, and now they're proposing that for anyone taking advantage of the general solicitation, it'd be 15 days before your sale, and also after you're done closing, 30 days after your closing, you'd have to amend it again. That puts a damper in EB-5 capital raises, since everyone seems to like to operate at a very quick timeline. There are some penalties for not following the Form D. And then there are additional language and legends that they're going to think about imposing. And then the key thing is that they're also suggesting that anyone taking advantage of public solicitation may be required to file materials with the SEC. And we're not quite sure what that is going to mean as an industry yet. You file with them with the SEC, they don't actually have to review them per se, but the fact that they have them, what does that really mean for companies? And of course, these are all proposed amendments right now, so they're not in effect just yet.
Jor, that is incredible. One would have thought that a guy like you probably graduated from Columbia University. Oh my gosh, you did graduate from Columbia University. What a smart one you are. That is incredible, Jor. Thank you. I'm not going to be able to sleep tonight after Michael Gibson and Jor Law terrifying me. I'm a little bit more positive. Statistics, yep, we got to watch them. But the reality is that, I think the program's viable. I'm doing a piece now on predictions for 2014, the year of the horse. That's my year. I think it's going to be a good year for the program. I think they're going to increase the numbers. I think that we're going to have a whole bunch of new projects. I think that the market is becoming mature. I have to dampen the negatives. I do believe in due diligence. I do believe in making sure you do not trip the securities tripwire. Otherwise, you will end up in jail or worse. But the reality is that I think 2014 is a good year. I think it's going to be a great year. I think 2013 has been as tough as it gets. I think tenant occupancy has been a nightmare. It continues to be a nightmare. So let's go to what I think is another optimist. His name is Kevin Wright. I've got to know Kevin pretty well. That's Wright Johnson. There he is, Mr. Kevin Wright, Wright Johnson. Kevin, you didn't put all your contact information. I think we have that at the end, but info@wrightjohnsonllc.com, wrightjohnson.com. Just Google him. Kevin does business plans. Kevin does economic analyses. Kevin has done lots of regional centers. Kevin has done lots of business plans. Kevin has done lots of economic analyses. How do I know this? Because I've read them, because I've worked with him. And excuse me giving a plug for my co-panelists, but he's a pretty cool guy, and he's going to fill us in on hot topics. And let's kick away. Kevin, this thing here, what is it, 924? That's our application, 6,230. I thought you were going to put up the 924A, but this is the current application form. I know you got a bunch of approvals. I remember one week I called, I got all excited. Yay, I got a 924 approval this week, and you really blew my cover by telling me you got about 10 approvals that week. So there you go. What's the story here, Kevin, with the 924? Are these things flying through?
Well, they're going through a lot faster than they were for a while there. 2012 was a very slow year where not many went through at all. You'll see that I think it's around 180 this year have been pushed through.
Repeat that number, 180 regional centers approved this year. That is
approximately, yes.
Approximately. Everything we say today has the word approximately. That was the disclaimer that we used right at the beginning. So what kind of evidence do you put in the 924 packages that you file? What sort of stuff is in there?
Well, one of the key things that's not written here, but that everyone needs to understand is that the biggest difference this year is in backing up all of your claims and all of your numbers, or what I'd refer to as the inputs to the economic analysis, such as your revenues and your construction timelines and the amount that you're going to spend on hard cost construction versus soft costs. You heard Michael talking about a lot of these people out there are jacking up the numbers of soft costs and adding in line items that make no sense. And I think the USCIS has caught on to this. And it really goes a lot easier for you if you go out and get a feasibility study. Things are so much better when you have a third-party feasibility study from a company, say like in hospitality, like a PKF or an HBS, who can validate all of your revenue projections, who can validate the time it's going to take you to construct your facility and the amounts that you're going to spend on it in the different categories. It is night and day, a lot easier to get approvals when you have third-party people verifying stuff rather than you saying, well, I built 10 hotels in the past, so I know how much it costs, and I wrote this up, and I think it's right.
So
third party is the key thing there.
Third-party, verifiable, detailed analysis, don't make claims, back those claims up. The government is saying, we are not stupid, come on. Make sure you provide information that is accurate and detailed. So, I mentioned earlier about geographical description. Everybody's trying to, what is a regional center? How big is it? Is it 1 county? Is it 2 counties? Is it 3 counties? Is it 2 states, 3 states, 4 states? Where are we going with geographical description? If my regional center includes, for example, Los Angeles County and Ventura County, does that mean I can go into Orange County or contiguous counties? Does it mean I can go 2 counties over? If I've got LA County, can I in fact do a project in San Diego County? What kind of amendment is required? Answer these questions for me, please, Kevin.
Yeah, absolutely. So in determining your geographical area to make a regional center, typically what we most of the time will see is an area of about 7 or 8 counties. You will read a lot on the internet nowadays about some recent approvals for these multi-state regional centers in these very large areas. Some of which I've worked on. We recently had an amendment approved for the entire state of Texas, for example, which contains a very large number of counties. That's all very possible, and you can do that, but the expense and the time required to put that together is immense because you do need to determine your regional center boundaries by one of a few things. One, the easiest way to go is to use a metropolitan statistical area, which is a government-designated geographic region that is a number of counties that are all tied together and is very easily definable, and you can use that as your region. They range in size from just a few counties to several. For example, the New York City combined statistical area includes 16 different counties and includes multiple states. We recently had one of those approved. You may also, the next most popular way to do it is through commuting patterns. And commuting patterns are, it's basically stringing together, you base it on a location of a specific project that you use for an example, and then you string together the counties that surround it where you can prove that people who work in the main county may commute in their car from another county. And if a significant amount of people do that, you can include all of the surrounding counties, which typically you'd get, say 3 or 4 counties surrounding the core county that would go with it. And you can use that as the basis for your geography to apply for a regional center. And if you want a slightly larger regional center, you can do multiple sample projects, and you can strategically place them in areas. Think of it like puzzle pieces, where as long as they're contiguous and the commuting pattern grouping is right next to the next one, you can string a few of them together to make yourself a larger geographic area. So you can imagine, for example, in the amendment to get the entire state of Texas approved, just how many individual analysis of how many sample projects had to be done to string together 3 and 4 county groupings to get the entire state of Texas. It was a tremendous undertaking and a lot of work, but it can be done.
So how does this next one work with, restaurants are very popular. I want to open up a chain of restaurants throughout Texas, 10 different restaurants, and using the franchise model. Can we, in fact, incorporate all of these different business entities within a single regional center?
Yes, inside of the regional center application, if you wanted an area large like the size of Texas, you would need to pick a business. The easiest way to go about it would be to pick a franchise, such as a franchise restaurant like a McDonald's, because you can place a McDonald's almost anywhere in America, and there are McDonald's everywhere. So that's a good way to show that, hey, we may want to do a restaurant franchise in the future, and we may want to put locations just everywhere in our state. So it's a way to show the need for a large geography or area through the use of a restaurant franchise. Whereas instead, if your sample project that you're using to get regional center approval is a county hospital, well, most counties already have their hospital, and there's not a need for them in most places. So you would have to place that very specifically in a place where it's needed. Franchises, they can go almost anywhere.
So fill us in a little bit. TEAs, in the last session we did, we went into the depth on TEAs, rural versus metropolitan statistical area. How important is the TEA, and how do you factor this into your determination when you are doing your economic analysis? And of course, this is the critical issue in determining the amount of investment within your regional center. And by the way, for a standalone as well, in terms of reducing the amount from $1 million to 500.
Sure. Well, as most people would probably agree in the general marketplace, the idea of getting $1 million investors versus $500,000 investors, most investors do not invest $1 million. They all would like to invest at the $500,000 level. So the TEA is very important. The TEA determinations on a project-by-project basis are determined in completely, each state makes their own determination and has their own process and rules that they allow you to use. I think Ellie went through a lot of that on the previous seminar, and it's a very complex issue. But the main thing that people get confused about, particularly in the regional center application stage, is to understand that the TEA area is not the same thing as your regional center area. They're two distinctly different concepts. And every regional center generally will have areas that are TEA areas and areas that are not.
So, Kevin, that, by the way, you mentioned Elliot, and that's Elliot Weiner. And those of you who missed our last one, you really want to listen to him. This is the TEA guru. But we were just chatting yesterday, and you commented that it had taken you about a year to get a TEA designation out of New Mexico, and apparently that's the first one they've ever issued. So in some states, it's a relatively straightforward process, like California, where they have an office, and in others, like New Mexico, it was an uphill battle. Is that correct?
Yes, you'll find that every state does it in a different manner. And like in California, they have a website. They list all the information there for you, and they also allow for customized applications for TEAs. But in many other states, they have no person in charge of this. In the case of New Mexico, there was no way to apply for a specific TEA. They had no one in charge of the program, and the governor and some of the other people there were reluctant to really want to get behind the EB-5 program and dedicate resources towards determining TEAs because they just didn't understand the value in that. They have actually finally recently come around, and they're going to establish such an office. But that was a very difficult process for a long period of time.
Bravo and well done. You know, the other big issue that we used to have that gave me a whole bunch of gray hairs was the NACE code obsession. USCIS was just totally obsessed with NACE codes and industry standards. So where are we today now based on the May 30th memo, and what are the practical applications in your 924 regional center application or amendment? How important are these NACE code things?
Sure. Well, the industry sectors, a lot of that changed once they came out with the May 30th memo this year. Just to finish up on geography, one of the things that changed with the geographic regions and where you can do a project and where you cannot on that May 30th memo is the fact that you can now go without filing an amendment, you can go after and try to do a specific project as long as that project is located very close to your regional center, even if it is not within the boundaries. Basically, an amendment to expand the regional center would happen with the 526 application. Now, that can be done in a very close proximity to the regional center boundaries. However, you cannot simply go from Los Angeles to New York because you think that that it makes sense to you. It does have to be very close, and your new location does have to statistically affect the existing regional center boundaries. Now, the similar thing that came out. Oh, go ahead.
No. I want to warn everybody on the next slide. I went through this. I spell checked it. I take full responsibility. There's a typo on tenant occupancy, which we're going to go into next, which is still the big bugaboo. So please pardon me. Tech specialist, help me correct that before we post it. I don't want to post the typo. So moving on from industry standards onto the headache of tenant occupancy. This blew in February 2012. It's been a pain in the neck, continues to be a pain in the neck. Where are we on tenant occupancy, Kevin?
Sure. Well, again, just finalizing the industry standards, that same letter on May 30th said that even though you still apply for a regional center with specific industry codes, you don't necessarily have to only invest in those industry codes. You can invest in other industries outside of the ones you're approved for as well. Tenant occupancy, that became the biggest thing and a major headache in 2012, and it continued on through this year. And basically the idea there is the government is not in favor of you counting jobs of your tenants. So if you build a shopping mall or an office building, they do not want the job creation of the tenant to count towards the EB-5 process for the building developer. Some interesting things that we've seen in recent months on this. For example, we always tell people you really do not want to go forward with a tenant occupancy project if this is a real project you intend to move forward on, because you have no idea how the government's going to rule on it, and you're putting a lot of money and a lot of time and effort into something that you don't know how it's going to turn out. Now, we have seen some recent ones where tenant occupancy has been accepted in very specific occasions, but in general, you don't want to go with it. One was a recent a hospital, where a hospital was being built, and on the property was a medical office building. Well, the government allowed the counting of the tenant occupancy jobs in that case because it could be proven that without building the hospital, there would be nowhere for these doctors who work out of the hospital to have office space. And therefore, the creating of the medical office building in the hospital itself really did create those tenant jobs. But that's a rarity.
No, so there are rare occasions, and the other situation is, when tenant occupancy blew, it really impacted so many of the existing projects, and it appears that those projects that did have 526 approvals were given some deference. So the people who had approvals seemed to sort of be okay, but the new folks with pending applications really got kicked hard by the tenant occupancy interpretation, correct?
Yes, they did. For a long time, you could not get a regional center approved if they had tenant occupancy as a part of it. Now, strangely enough, we're seeing a reversal on that in recent weeks, where now we're seeing tenant occupancy regional center applications fly through with no RFEs, and they approve them on a hypothetical basis. However, it's important to note that just because your regional center was approved using a tenant occupancy as the basis of it does not mean you'll ever get a project approved using tenant occupancy.
If we had more time,
If we had more time,
I would ask everybody to listen to you repeat that last statement, because it just baffles me. Previously I had neurosis, now I have a double headache. I guess I gave myself that headache, but we are recorded, so that is amazing. Let's go on to the other really hot topic. I always keep the best for last. For those of you who think you could sneak out of class early, we've got really all the juicy issues here, so you have to hang on. Construction jobs. When do we get to count them? When can we not count construction jobs?
Yeah, direct construction jobs. You can always count the indirect construction jobs. However, if you want to count the direct construction jobs, the construction period has to last 2 years or more. And we're in the regional center mode here, right? Just remember that we're not talking about direct or standalone. We're talking about regional centers. Correct. And one of the things, because in a standalone, yes, construction jobs are not something you want to go with. But in a regional center concept, yes, the 2 years or more, as long as the construction period lasts that long, you can count the direct construction workers as well as the indirect. However, this is where third-party verification and really becomes important, because you have a lot of developers, when you explain that to them, all of a sudden when they sent you 2 weeks ago a construction timeline that lasted 17 months, all of a sudden now it lasts 26 months because they forgot about something. Well, just because you decide that your construction period, you think it's going to last more than 2 years, again, the USCIS is not going to take your word for it. They've been recently conducting phone interviews to talk to the different service providers and the developers to basically say you're going to need some third-party verification. You're going to need to prove that your hotel is going to take 2 years to build. Because, in a recent conversation with a USCIS economist, he basically said, before I took this job, my job was in the private sector to help developers to build hotels in the private sector through my use of analysis and to get the permitting done. And, through that, I know that unless you're building a very large hotel, there is no reason that a hotel should ever take 2 years to construct. So you're going to have to go out of your way to prove to me why this particular one is going to take that long if you want to get credit for that. So just to put this in simple terms, if I'm the project architect and I write a letter saying, I think this project's going to take 2.5 years for the following 5 reasons. One is I'm very slow. 2 is I measure 5 times and cut once. That's not going to cut it. Is that what you're telling me? If I verify as a project architect that why my project's going to take more than 2 years, that ordinarily is not going to work. They want some other architect or other sources to cross-verify. Is that correct? Yes, and the more the better. We often see people going out and get a third-party construction company to write a bid to develop the project, and included in that bid is a timeline talking about very detailed what they will do week by week or month by month during the entire process, and why it will take a particular period of time. How long will it take to do the foundation? How long is it going to take for the drywall? So forth, and really breaking it down into detail so that the adjudicator can see and compare to industry standards that, hey, you do fall within industry standards and this makes sense, or that there's something way out of whack here, and why is it going to take you an extra year to do drywall? Kevin, you're amazing. You're really amazing. You sound like a guy who really does this, knows what he's talking about. Every time I listen to you, it just gets clearer and clearer, because, quite frankly, it kind of all seems to make sense, and it's fairly simple, whereas, so many other of those webinars where you pay hundreds of dollars and seminars where you pay thousands of dollars just get me completely confused. And I listen to Kevin, and I listen to Jor, and I listen to Michael, and I really get it. This stuff is logical and simple, and finally somebody is demystifying it. Thank you for all of those listeners who send in emails and say, you guys are a whole lot better than the paid seminars and webinars. We actually learn how this thing works. That is my mission. My mission is to explain it and to demystify it, but I'm on a positive mission. I call myself Positive Bernie. I'm always upbeat.
I have a little 9-year-old. Boy, we went trick-or-treating on Halloween. It was so much fun. Bernie, keep on topic. Having a 9-year-old really keeps you upbeat and positive, folks. You should have seen his costume. It was amazing. And mine was so lame. Anyway, timing, positive. 2014, it's the good year. Approvals, how long are these things taking? They're doing the 924s in Washington right now, all of them. How fast? How fast are you getting them through? Let me know, Kevin. What's the speed?
I see that it's getting much and much faster. I mean, for a while there, you were out 14, 15 months. Now I routinely see them go through in 10 months. And I expect it to actually get shorter than that coming up.
So one of the predictions, sorry, that was rude. One of Bernie's predictions is we're going to get 924 approvals in under 6 months, starting sometime next year. I've been wrong before. What do you think of that prediction, Kevin?
I think that you got a good chance of it, particularly on a hypothetical application. Actual and exemplar applications, they do look at a lot more closely, which is a good thing. But they're going to take a little bit longer. But even those are dropping in the amount of time they take dramatically.
So a few more recent developments I know have been going for quite a while is the in-person meetings with USCIS at the California Service Center. Tell us, what are you hearing? What are you seeing? What's going on? What are the other positives?
Just the positives that I can say or, speak to is being on some of these phone calls. Rather than issue RFPs, they are, adjudicators are reaching out and requesting phone conference calls and in-person meetings to just go over issues and clarify things in a lot faster way than issuing RFPs, particularly when the RFPs are not always clear what they're asking for. They allow for 30 to hour-long minute meetings where you can ask questions and be interactive. And, from being on the phone calls, I was pleasantly surprised that it was not combative in any way, and that the answer was not, well, we'll have to look at that on a case-by-case basis when you reply to us. It was, well, yes, that sounds reasonable, or no, that doesn't sound reasonable, and giving real feedback with real people and real back and forth. They ask you, hey, how long would you like to take to respond to this, rather than just issuing you some demands. So
and Kevin, that's my experience as well. The face-to-face interaction has been extremely positive. The telephone conversations have been positive. USCIS is getting positive marks here. Bravo, folks, reaching out, practically, realistically, resolving the problems, telling us what you want, telling us what you don't want, and being very, I won't use the word flexible, but certainly understanding in terms of the real issues that we face, and we're finding positive developments, hence my positive attitude for 2014. Folks, we have one more speaker today. Kevin, listening to you is always enlightening. Thank you for being our resident participant, and let's start preparing maybe something together, which is the positive outlook for 2014. There he is, Mr. Wright Johnson, 561-282-6099. Call 561-282-6099. Sorry, wait a second. That was a plug. Info at Wright Johnson LLC. These folks do not get paid for participating, so the worst I can do, the best I can do, should I say, is plug them a little bit. We're going to take some written questions at the end, but last but not least, we have Mr. Ali Jahangiri. Ali, absolute pleasure to have you today. EB5investors.com. You go ahead and Google it. Welcome for joining us today. Ali, thank you so much for being with us. Tell us, what exactly is EB5investors.com?
In a more easily said, term, it's a platform that it allows people to ask questions. I see lawyers actually use it all the time. We're getting a ton of questions coming in, and these questions go out to a couple hundred attorneys that are listed. We have about 400 attorneys and professionals listed on the site that respond to these questions. So a lot of these technical questions that you have, you can just go onto the site and ask it, and it's anonymous, and you get the answer. It's really interesting to see attorneys ask other attorneys questions. It's kind of a new phenomenon that I kind of like about the site. There's just so much information, and no one person knows it all.
And Ellie, you have a background in social media and online and SEO. You're quite the guru in this. You've been doing this for a lot longer than many of us, correct?
Yeah, we had a site called Law QA, which has 6,000 attorneys on it that ask questions. We were a competitor to Avo. We felt that this industry, it's an industry getting tons of attention, and the internet searches are going up for EB-5, and you got systems being built, you got big players, big developers coming in, politicians getting more involved, and your local politicians, everyone's talking about EB-5 as a great way to bring talent into the country. So we figured it'd be a great industry to have a Q&A platform and build out a community and bring everyone together and highlight the top attorneys, the top service providers, and really get out there, get the message out there and unify the group.
I know Michael Gibson's website does some of it as well, but what does some of it, does all of that as well, and has been around. You're one of the new players that seems to be having an impact, and you put on great conferences, but why does your SEO work? What's so effective about your SEO?
So when the attorneys, it's for free. Any attorney can have a profile on our site. They just have to have experience in the EB-5 world. They have to at least have filed a 526 or a 924, or in the securities side, they must have put an investment package together. Once they sign up for free in our system, they just send us a request. We connect that with their social media. So automatically their Twitter, their Facebook, and their LinkedIn get all of the feeds. Every time they answer a question, it automatically feeds to their entire social media. So they don't really have to do much. They respond to an email, and we have a proprietary software that takes that email and posts it on our site and distributes that in social media all at once. So you know how busy people are. They don't want to go there and log on to these different social medias. All they have to do with us is reply to an email. And so we make it simple.
So, Ellie, I'm reminded of Groucho Marx's famous joke, I wouldn't want to join a club that would let people like me in it. So tell me about your EB-5 resources, and where did you find that 15-year-old picture? Do you know how old I've got? I'm an old gray-haired man, and that man up there.
You look great. Bernie, you look absolutely great in that picture.
You're much too kind. Flattery works, and by the way, abject flattery works even better. My new phrase, abject flattery. That's Mr. Goodlatte. Did you tell him when he came along that he needs to fix our immigration lawyers? Did you know Mr. Goodlatte is a former member of AILA, the association of which I'm a proud member and past president? Mr. Goodlatte, former AILA member, he holds the key to fixing this problem. He was at your conference opening speaker, I guess 2 years in a row. Hopefully he'll be back there next year. Did he promise to fix this? What are the resources you guys provide?
Yeah, we've been on calls with them, and we have lists of things that we need to, first of all, it's the education times, which we're working on with him. So we've been in contact with him very closely. There's a few of our members that are actively involved, some of our panelists that have gone on conference calls with him, and the attorney that's in charge of the council there. And we're working on it, and it's on the top of their list. It's something to work on. And he was actually supposed to meet with USICS director, was it last week, or I think it was 2 weeks ago he was supposed to meet with them about this. And so him and Fishman have been working on it. He's actually supposed to speak at our next conference. He's a great guy, and I'm really happy that he's an immigration attorney, which makes him a perfect candidate to help this program out.
And by the way, George Fishman, I have met, is his chief counsel, used to work with Lamar Smith. These are the guys who actually, we talk about congressional change and new EB-5 laws. These are the guys who actually draft them, who actually push them through. It's wonderful that you are networked in with these esteemed gentlemen who hopefully will not only fix some of the problems, but guarantee that the Regional Center program will be extended and that some of the problems like the retrogression and waiting line problem. There's your magazine. I guess it's online. I did a little article on Chinese retrogression problems and issues. got a little compliment, by the way. One of the lawyers said, finally, he understands it, which is good, because every time I read it, hear the issue and study it, I have to read my own article to remember how complicated CISPA can be. So the resources here are amazing. Tell us a little bit about this magazine.
Well, the magazine has a board, and the editorial board, Jor's on it actually, who's on this call, along with Henry Liebman, Pat Hogan, Bill Stenger, Linda Lau, David Herson, and we are soon to get Bernie on our board as well. We've been talking about that. So we have a great editorial board, and hopefully you get to read the magazine. It's our second issue, so we're new. And we highlighted the top 25 attorneys, and this basically was taken from a peer-reviewed survey on the top attorneys. And we actually went out there and talked to a lot of the editorial board members and people in the community and listed the top 25. And then we added 7 securities attorneys that are specifically involved with EB-5 that we feel know the details they need to in order to put these prospectuses together. So we kind of narrowed down the due diligence for you in terms of picking a lawyer, someone who's an expert.
Well, Ali, sorry, that was rude of me interrupting, but it seems like you really know what you're doing in the SEO arena and have dived in, and I know you have a good team. I've met with several of your people, and the top 25, really had nothing to do with good looks. I'm sure of that. You know, I'm going to fly through them, and then I'll stop on some of the people who happen to be my friends. This ugly guy got in, the ugly guy on the right, Bernie Wolfsdorf. The other guy probably knows what he's talking about. You know, there we are. Steve Yalur, my good friend. David Herson, a good friend. Ira Kurzban, when you need to sue, he's a litigator. Ron Klasko, you know, major thought leader in this area. Robert Devine, former chief of USCIS. Kate Kalmakov, I'm doing a panel with her. Oh, I forgot to give that plug. Those of you lawyers, January 24 in the Cayman Islands is our AILA program. Go to AILA.org. We have a one-day program on investors. The program's going to be knockout good. Half these guys are going to be on. I selected Kate as my co-panelist. You know, this is how popular it is. I did hear that the hotel reservations are already sold out. The hotel is sold out, folks, so you're not going to get the cheap hotel rate. Marty Lawler, Mark Ivaner, I used to work with Mark, two good people. Linda Lau, hey, that's my buddy Chuck Hook. He's my brother, different mother, but good friends. He was the AILA president before me, and as Chuck once said, you know, Bernie, we're so very different, but I'll cover his back at all times. He's one of my best friends in immigration law. Dale Schwartz in Atlanta, Darren in LA, another South African-born fellow. Angelo Paparelli, another thought leader, very good friend of mine and mentor. Anthony down in Florida. Boy, David Morris in Washington. Dawn Lurie also in Washington. Ed Bashara, got a similar accent to mine, but his is Australian. Jeff Campion in Texas. Same old culprits. You go to every conference. You're going to round up the same bunch of guys. Brandon, Kevin just told me took moving up north, but a player, Jen Hermansky, another player in the industry. Mona, I just did a panel with Mona and Reza, also a player in DC, Bob Gaffney. Those are the 25. And there, that Mr. Jor Law, trust me, he looks like he's 19. He gets carded every time he goes into a bar, but he's actually like ancient. He's, you know, like 45 or something. He's my go-to securities lawyer. Steve, another player in the business. There's Jor's partner, Michael Homier. Picture tells 1,000 words. Some more players. Ronnie got a great sense of humor. And John, those are some of the securities. I haven't met, don't know Osvaldo well yet, but there we go. Question and
Bernie,
answers.
I was just going to mention our next issue is regional centers, and the magazine will have a directory so you can contact any other regional centers you need to get a hold of. and that's the topic for the next magazine, which is going to be out in late January.
Well, I better hook up with Kevin and get my little pencil out. Ellie, you're one of the people who I think has brought so much to the industry with the conferences, understanding SEO, getting the message out. You and Michael Gibson, Michael's been doing this for years. I know you've been on the scene the last year or two, but you've come in with a big bang. Ellie, thank you for joining us as our guest today. It's wonderful having you on board. We have a gazillion questions. I'm going to try and answer them really quickly just because I'm looking at the time and we've got to try and finish. When do you think the new office in Washington will take over pending 526s and or 829 cases at CSC? Have you heard anything? Yes, I've heard lots. I've heard that CSC is going to be finished by the end of March. I don't personally believe it. My understanding is that, and please don't quote me, this is rumor mill, folks, that about 60% of the cases are already being adjudicated in Washington. Washington is up and running. Kevin, if you're on there, I think you had some statistics about how many economists, how many examiners we have in Washington as of today. Kevin, what are your numbers?
Well, I'm not certain.
Sorry, I probably caught you off. You're the one who told me. Somebody told me how many economists they got in Washington.
They have quite a few working there, but I wouldn't be able to tell you the exact number.
Somebody gave me the number, but it went in one ear and out the other. Bottom line is it's moving, it's moving, it's moving, and it's moving fast. If the primary EB-5 applicant abandons his conditional green card, will it affect the dependents receive their permanent cards? You bet it will. If the primary gives up prior to the approval of the 829, if the primary dies, by the way, then maybe it will be different. Or if the primary and the second and the primary and the derivative are divorced, you may have a situation where the derivative could be okay. But no, if the primary pulls out, you got problems. Or shall the primary applicant stay in the green card process through the 829 process in order for his dependents to receive? You betcha. You betcha. You better stay in there, Mr. Primary or Ms. Primary. Thoughts about approved regional center taking on new project outside its geographic area, original approval? How far can you push the line? Kevin actually addressed that. Follow it up to info@WrightJohnsonLLC.com. Contiguous seems to be okay. I don't know if we really answered the question. Can you go 2 counties over? Look at the factors that were raised. Is there a CPM critical path method out there listing the required EB-5 events, scopes of work, responsible parties, expected event timeframes from the creating 924 submittal through EB-5 project completion? I kind of messed your question up because I'm trying to go too fast. Is there a CPM critical path method out there listing the required EB-5 events, scopes of work, responsible parties, and expected event timeframes from the creation of the 924 submittal through EB-5 project completion? I think not. I don't know if Michael Gibson's still there. Michael, do we have a CPM at all on any of the projects?
Yeah, Bernie, I would ask that to Kevin. We don't file 924, so I wouldn't know the answer.
Kevin, you want to have a shot at that? Did you get the question?
What is the acronym again?
I'm wondering if I understand the question. Is there a critical path method out there listing the required EB-5 events, scope of work, responsible parties, and expected event timeframes from the from creating the 924 submittal through EB-5 project completion, a CPM?
Yeah, no, there is no official listing of the things that need to be included in the application. I mean, I can tell you need an immigration attorney, you need an economist, an economic report, you need a business plans, you need a business plan for your regional center, you need some sample documents and some other things, and a variety of team members. But there is no official, you have to have this or that. And then in terms of the timeline, you can look on the USCIS website, and they will show you the approximate timelines of where they're at in terms of adjudication timelines. But they tend to be, by the time you're reading the timeline they post, that timeline has shifted, usually quite dramatically. So it's not always that accurate.
I'm going to go try and fly through some of these questions. I kind of stutter and hum and ha when I need verification of the answer. Otherwise, I'm shooting from the hip. If the EB-5 applicant is in H-1B status and his or her investment funds are the donation of his parents, shall the EB-5 applicant prove that he or she owns more assets than 500 in order to qualify as an accredited investor? No. If it's standalone and direct, you don't need to worry about that. That's for a regional center if you're investing in your own project. I won't have this concern if the applicant is not accredited. No. This is, you don't need protection from yourself. I'm the only one who needs protection from myself. They gave me a white jacket with no sleeves. Somebody said, not irritating, rock on, thanks. You actually like my silly humor. Will slides be available on the after session? Yes. Client has invested $400,000 into EB-5 project, but can bring over remaining $100,000 over until next year due to currency constrictions, Indian currency constrictions. Can he file now and invest later? Yes. It says investing or in the process of investing. So just make sure that you can show that you're going to bring over that extra $100,000 so you can make $500,000. Moving on quickly, my proposed EB-5 project consists of over 800 apartment units, 200 homes. Several hundred permits will be required over the course of a 30-month term of project. Is it a requirement of USCIS for all the permits to be pulled before the actual plan is approved, or would letters from the general public stating that the permits are allowed be satisfactory to USCIS? No, not all the projects have to be pulled, but you do need the verifiable detail. This is from my friend Tyler. Tyler at Continental. He's thanking me for the plug. Hey, Tyler, I didn't know you were going to be on board. Thank goodness I did the plug. This is USA CRC. Thank you for the recommendation. Yeah, I really believe it, and so do many of my panelists. EB-5 is in first position, and we have no plans to run away to Mexico. Whew, relief. Why don't we go on vacation to Mexico, my favorite place, but the EB-5 investors in your project are apparently in first place. I knew that. I'm just repeating it. What is the typical or reasonable percentage of soft cost development fees? Oh, another good question. What is a typical or reasonable percentage of soft costs development fees? I think that goes to you, Kevin, or that would go to you, Michael Gibson. Reasonable soft costs, what are you accepting?
Bernie, this is Mike. So I don't know if there's one standard. It depends really on the scale. In your smaller scale projects, that number could be higher simply because it really costs almost the same amount to do the engineering drawings and architectural for a $5 million as for a $50 or $100 million project. So it depends on the size. I'm going to start sounding like USCIS, but it's project dependent, and I think you have to look at it. But I would say anytime you're getting close to 50% soft costs or even 40%, I would be highly suspicious of it.
So a lot of good questions here. What is the typical or reasonable percentage of soft cost development fees? Another one to you, Michael. Roughly speaking, what are acceptable percentage levels of the following in a typical capital stack? Roughly speaking, what are in a typical capital stack, assuming the other items pass muster: senior debt, non-senior debt, including EB-5 capital, and at-risk equity. Want to do a very quick breakdown. I know we can't get into the weeds on that.
Yeah, from an immigration attorney's perspective, you want the EB-5 component to be as small as possible because you're jealous of all of the job creation that will occur. You never know how USCIS will adjudicate, as Kevin explained, regarding the indirect and even some of the direct if you're using TO. So if I'm an immigration attorney, I would love to see a project with only one EB-5 investor because any job creation that they make is going to come to me. With the levels of debt, the interest rates 6, 7, 8%, debt is not an issue. So having a bank loan in that takes in 70–80% of the stack, that's great. The smaller the EB-5 component, the better.
Excellent. Thank you so much. Hey, and Jor, looks like you got another fan here. Kudos to Jor. This sort of service is badly needed in this and other fields of law in order to stimulate business development. Wow. Looks like somebody agrees with you. Is there a way to print off the pages? Yes, when we publish it. Lots of pretty well-known people here. I'm impressed. What the same apply for a service-based franchise rather than a food company? Oh, I'm sorry, Amy, I don't get the question. How and where can we find out TEO locations in Texas? Wow, TEA locations in Texas, very complicated. Texas has its own formula. Texas is quite unique. Kevin, you want to elaborate on that one?
Just simply that you would, in Texas, you want to hire an economist to put together the data for you and to request that you be granted a TEA designation. And in Texas, which is different than other states, is that it's done locally. So a city mayor or the judge in a particular city or town is the one who makes that determination. It's completely different people in different areas rather than most states where it's all one office and one.
So the local judge in Texas does it. Wow, Texas does it different. But you know what? There are a lot of good programs in Texas, and obviously their pro-business attitude comes through. Good afternoon. Hi, good afternoon. I have a question for Mr. Kevin Wright. Do we have to request geographic areas that are contiguous and clearly delineated? I think the answer is yes. What if we cannot prove the continuous line with the MSA and commuting patterns for the counties that connects the targeted counties that are going to have actual projects? Kevin, do you want to elaborate on that a little bit?
I mean, there are. You need to, in some way, figure out how you're going to show how the different counties economically affect each other and act as a unit or together. You can do that through a variety of ways. The MSA and the commuting patterns is simply the most popular ways, but there are other ways, and you can have economists do that for you.
Thank you, Kevin, and reach out directly to him for more specific. Here's another one from an old player. I see many players here. I noticed new programs involving residential condominium development projects. This used to be a problem in the 90s, especially where the investor is also a purchaser. Is USCIS becoming more lenient on this? Not on the redemption side, but in terms of counting construction jobs, yes. So these programs are moving again, housing, condominium projects, the bigger ones. Kevin, what's your scoop on this?
Well, I mean, simply that, if the larger construction projects of apartment buildings and condo buildings are working, the main driver behind the jobs there is the construction. So larger condo buildings generally tend to work better, as well as those tend to have more complicated capital stacks where you're going to have EB-5 doesn't tend to fund the majority of the project. Usually there are bank loans involved, maybe some tax financing or some other things where EB-5, the percentage tends to be less than 50%.
I love answering everybody's question before we go. This is the webinar where everybody gets their questions answered. This is not legal advice. You have to call one of us to get proper legal advice because I'm reading so fast and I don't have my reading glasses on, so who knows if I'm even getting it right. Let's see, what else is this one? Not directly related, but any comments on current processing times for 526? Trending down, hopefully. I'm going to say yes, but USCIS uses a system called LIFO, that's last in, first out. Sorry, bad joke. Not actually a joke. It seems like the new filings are going to go faster, and some of the old ones with tenant occupancies are still stuck. Bernie, you keep mentioning retrogression. Actually, the correct word is backlogs, and I looked at your article regarding the same. It seems you're focused on and most worried about retrogression for China. Yes, it's a China issue. And I think it's going to impact China. Do you see retrogression only affecting China? At this point, the predictions are it's only going to impact China because China is using about 80–85% of the visas. We'll see how this actually comes out. Stop the questions. I'm going to take any more. Is it possible for a franchise to be receipt of a regional center. Kevin kind of answered that, and I think that is correct. This question, I hear that there's been mention that 526 would be approved by March 2014. No. What I said by March 2014 is that that is supposedly a date where CSC is no longer going to be doing 526 and operations will have been shifted to Washington. I'm not sure if that's a hard deadline. Are direct construction costs determined based on the relationship? Kevin, get ready. Are direct construction jobs determined based on the relationship to the employer or based on its relationship to the economic input, hard costs / soft costs? The May 30th memo does not speak precisely to this point as it relates to construction jobs. Kevin, you want to have a shot at that?
Construction jobs tend to be based upon the input to the analysis. So construction jobs are counted as based upon the amount of money spent on hard construction, and there are some eligible soft costs such as architectural and engineering costs that can be used to also derive jobs. But the majority of it is all from the hard cost of construction, and that's a multiplier based upon the amount or the number of millions of dollars spent on hard costs of construction.
Bottom line is keep that soft cost ratio down. We can choose we can choose San Francisco to invest in high tech. Well, yeah, it could be up there. We come across a job creation method used by some RCs, that is a method that counts the number of jobs based on the amount of investment. Does that make sense? Yeah, amount of investment. Kevin, if you can comment.
Well,
job creation methodologies using the amount of investment. One of the criteria, sure.
It does not make sense if you're talking about straight, hey, our project, we're going to invest $10 million of EB-5 money into this industry with no explanation of how exactly you're going to spend it or what that money is going to do. So it is important to understand how you're going to spend the money in the industry.
Verifiable detail is the phrase that we need. So spending the money is relevant, but you better show how you're going to create the jobs. Merely because you're going to go and spend a whole bunch of money doesn't necessarily work. The government wants verifiable detail. Question for Kevin. How are you dealing with the 2.5-year rule with construction that lasts 2 years, but with revenue that lasts well beyond the 2.5-year rule? Great question, Michael.
If you mean that the construction, say, would last 26 months, and then the revenue from the project would go on and last for a long period of time thereafter, that is a difficult situation because technically you only have 4 months there to count revenue. On the side of how do you count revenue, and this is one of the things I talked to an adjudicator about recently, or the USCIS economist on the phone, and he said that he preferred that we actually count revenue from operations on a month-by-month basis and add it all up and use that as the input rather than to annualize it. For example, let's say you had 2 years of construction, and then you normally what we used to do is count the full third year as the input for the amount of revenue that would drive the amount of operational jobs at a project site like a hotel. Because the argument is, well, to run a hotel for an entire year, you need the same amount of people in the first half of the year as you do the second half of the year. So you just use an annualized number like the model works. Instead, the adjudicators preferred, they said that in the future, please add up the first 6 months of revenue and just use that as the input and do not annualize. So whatever amount of months that you have left in the 30-month period, you use the revenue on a month-by-month basis, add up 2 months, however money you have left in your 30-month period, and that's what you can use as the input to the model for operation.
I'm going to take the next one as the last question, but there's another one here for you as well that just got added, Kevin. I need to sign up and wrap up here. The question is actually to me, do you see U.S. Just by the way, there's no regulatory or statutory basis for this. So do you see USCIS revisiting the rule, or is litigation needed? Litigation, regulations are needed, a lot of guidance are needed. Is this issue going to get litigated? It's quite possible that it has or will be litigated. Kevin, have you had any indication that USCIS will revisit the 2.5-year rule?
Well, I leave that to the lawyers. I hear a lot of them talk about the fact that it should be revisited and that it's not a correct rule. However, as far as litigation goes, not my expertise.
The bottom line is a lot of talk. Talk is cheap. We've got to see some action. Last question of the day. Looks like it's you, I guess, Kevin. Oh, wow. Somebody's saying thank you. We love thank yous. Do construction jobs have to be still in existence at the I-829 stage, or can the I-829 be approved even though the project was completed before the 829 stage? We were wondering how, quote, permanent the full-time permanent jobs had to be. Question to you.
Yeah, well, at the 829 stage for your construction jobs, you need to verify the input to the analysis. So if the input to the analysis for construction was the amount of money spent on hard construction, say that's $5 million, then at the 829 stage, it doesn't matter if the money was spent, that the construction is still not ongoing, as long as you better have receipts to prove that you spent that $5 million you said you had spent. It doesn't have to be continuing on after, while the 829 is being approved, but at some point you need those receipts.
Kevin, you are amazing. Ali Jahangiri, EB-5 Investors Magazine, Michael Gibson, as always, amazing. Jor, you guys are incredible. This is the EB-5 webinar series to listen to. Share this with your friends. It's on YouTube. I guess if you Google EB-5 and my last name, Wolfsdorf, then again, if you can spell my last name, you should get a Nobel Prize. But bottom line is absolute wonderful being with you here today. Watch for next year. We're going to have a lot of other guest speakers. Thanks for demystifying, and look forward to a wonderful year. 2014 is going to be a good year. Mr. Goodlad, the R's and the D's are going to get together, pass good legislation. This program is great. It brings jobs. It brings capital. We need jobs. We need capital. And on this beautiful day from lovely and sunny Santa Monica, we wish you a lovely, lovely day, wonderful year, and may the EB-5 forces be with you. Sorry, I'm an old guy. Thanks again, and goodbye, everybody.